All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. If you are near, give your attendance and you shall be heard. I'll see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I apologize for the slight delay this morning. We had some technology issues. I am Chief Justice Amy Blake. To my right is Justice Vicki Henry. To my left is Justice Rachel Hershfang. We will be the panel for the 6 cases that we will hear this morning. Most of you have been here before, but just to go over a few ground rules. Each side is permitted 15 minutes of argument. There is no rebuttal. I know that we have some time splits on 3 of the cases today, so I'll ask you about that when you approach. I will assure you that we have read all of your materials, so use your time wisely. Get right to the argument. We will likely take a break after the 3rd case for a brief morning recess. With that, I will call the first case, REVOLI Construction Company, Inc. versus the City of Worcester, docket number 24P1215. It looks like this case is partially impounded, so please comply with any impoundment orders in this case. Counsel? I understand Mr. Peterson will have 10 minutes and Mr. Ryan 5. Is that correct? Thank you.
That's correct.
Ready.
Madam Chief Justice, associate members of the panel, and may it please the Court, good morning. Neil Peterson, together with my co-counsel Stephen Ryan, for the appellant, the City of Worcester. The City is appealing 2 errors by the trial court with respect to REVOLI's bad faith claim. The first is the trial court's ruling that the City was not entitled to a presumption that it acted in good faith when it rejected REVOLI's bid for the Route 20 sewer extension project. The second is the trial court's ruling that the record supported a finding of bad faith despite the lack of any evidence that the City used its responsibility assessment as pretext or that the City rejected REVOLI's bid pursuant to an improper ulterior motive. The City's basis for its rejection decision was its discretionary judgment that REVOLI was not responsible within the meaning of the public bid law statute. Under the statute, the City was required to reject REVOLI's bid if and when it possessed information it considered reliable indicia of REVOLI's non-responsibility. REVOLI argues that the City unreasonably relied on insufficient indicia and rendered a premature responsibility assessment which REVOLI labels a predetermination. Even if we accept this argument, REVOLI has failed to demonstrate that the City acted in bad faith because REVOLI has expressly conceded that the sole motive for the City's rejection decision was its sincere belief that REVOLI was incapable of responsible performance on the project.
What is our standard of review on this question?
The standard of review for both issues, because they both involve a question of law, would be de novo.
And can you just, maybe it's me, I haven't asked my panelist. I don't know what a JMOL is. I know what a JNOV is, but can you tell me what a JMOL is?
Yes, Your Honor. The City brought 2 separate motions, both in trial and then post-judgment. The first was a motion for a directed verdict as a matter of law. The second was a motion for a judgment notwithstanding the verdict. So the City, as an abbreviation, used JMOL to refer to both because the City believes that the arguments raised in both were consistent. I missed that day of law school, so I appreciate the help. Happy to help, Your Honor.
So you say it was error to conclude that the defendant was not entitled to presumption of good faith. Why is that not an abuse of discretion question?
Because the trial judge ruled that the presumption was not applicable in this case. And specifically, the trial court dismissed the applicability of the 1939 SJC decision in Slocum v. Medford. And the reason for that dismissal was the trial court found that Slocum was no longer applicable in the wake of the 1980 bid law reforms. However, as is noted in the City's briefing, the City cites multiple Attorney General bid protest decisions in which the AG's office cites to Slocum both for the proposition that the presumption applies within the context of a public bid rejection and for the proposition that the presumption cannot be rebutted by mere speculative inferences of bad faith intent. Now,
I just want to poke that a little bit. I mean, I just want to make sure I have the facts here correct. The jury was instructed on the elements of bad faith, and there's no disagreement that the elements were correctly instructed. Is that right?
That's correct, Your Honor. And I'd highlight that the distinction the trial judge raised in the jury instructions between an arbitrary and capricious bid rejection and one rendered in bad faith. And the trial court correctly noted that that distinction lies in the critical element of an ulterior, improper motive for rejection.
And the jury, having properly been instructed, then rendered a verdict that the city had acted in bad faith.
That's correct, Your Honor. Our argument in our two motions is that there was no evidence on the record from which the jury could infer.
I understand that. I'm focusing on your first argument now, on the good faith one. So putting aside the question of the reliability of the verdict that was rendered, I think there's sort of a conundrum here in your maintaining that you are entitled to a good faith instruction in the face of the jury's having concluded there's bad faith. Isn't it, just as a matter of practicality, impossible that the jury would have applied those instructions to find bad faith without necessarily concluding that there was no good faith?
The proper articulation for the presumption is that it establishes as fact the city's good faith intention for the rejection of REVOLI's bid, and specifically that the city rejected pursuant to sincere concerns about REVOLI's capacity to perform. If the trial court had instructed the jury that it was to accept as fact that the city so acted unless REVOLI was able to produce evidence demonstrating the insincerity of that purpose, we believe the jury would have found for the defendant. And that's consistent with this Court's precedent.
But let's test that with the hypothetical. Let's say that some competitor somehow whispered in the ear of the city person doing the investigation and said there were performance problems. There was no basis to it whatsoever, but the city believed it. And then the city did its due diligence here and disregarded everything that was positive about the contractor and just lasered in on everything negative about the contractor. You're saying in that circumstance that there could be no liability?
Not that there would be no liability, Justice Henry.
There wouldn't be no bad faith?
There would be no liability for bad faith. That would certainly provide ample evidence for an argument alleging arbitrary and capricious decision-making. But the city is aware of no authority that stands for the proposition that a targeted investigation into perceived flaws on the part of the putative low bidder, even when that investigation is used for the purpose...
That just does not seem possible that could be the answer, because it would allow so much mischief. And isn't the point that the city has to do a fair review of ability, considering the good and the bad? And it can't... I mean, if you take any person in this room, if you take any company and you only look at their worst day, they're going to look terrible.
Two responses to your question, Your Honor. First, I believe the SJC in the 2012 decision of Barr v. Holliston weighed the balancing of providing awarding authorities with the ability to conduct a discerning investigation into the bidder's responsibility against the possibility for favoritism. And the SJC said that the balance shook out in favor of the authority, and that was consistent with the Ward Commission's recommendations. Second, I believe the 2024 Attorney General bid protest decision, GEG Construction versus the Town of Longmeadow, cited in the city's briefing, speaks directly to your question. The city believes that GEG is particularly instructive in this case because its facts have many parallels to the allegations raised by REVOLI. In GEG, the Attorney General considered clear evidence of a bias against GEG as the putative low bidder, as well as evidence that the authority used its investigative process for the sole purpose of building a case for rejection. Now, notwithstanding that, and notwithstanding the AG's criticisms of the process as being circumventing of the bid law requirements and depriving the bidder of a fair evaluation of its bid, the AG did not find bad faith. It deferred to the good faith motives for the rejection decision. And what it did was it dismissed the information gathered through the flawed investigative process that had been corrupted by the bias as unreliable and arbitrary and capricious. It then turned to consider whether there were independent indicia of non-responsibility upon which the awarding authority could premise its decision, and it found in the affirmative. Now, that's consistent with the 2003 Attorney General bid protest.
Yeah, but wasn't that the case where the decider for the city or the municipality had personal bad experience with the contractor, so there was this independent knowledge that so we just cut off the terrible investigation and we just look at that independent knowledge?
That's correct, Your Honor. That
we
was
don't
the
have that here.
We don't, but the Attorney General has repeatedly said that we need not have personal experience with the contractor to be able to identify indicia of non-responsibility. In the AGO bid protest decision involving Cape Cod builders
Don't you have an obligation to provide some fair, however you define fair process for evaluating these bids?
Yes, Your Honor, and the appellate decisions and the Attorney General's office.
When you put your finger on put your whole hand on the scale and say we're only looking at negative and we're going to throw out all the positive, how is that possibly literally a good faith effort to try to evaluate?
The good faith component comes in the honesty of the purpose. And so what that means is that the awarding authority must make its rejection decision premised on the statutory power vested in it, which says that if it's in the...
for you, we have to conclude that as long as you had this pure heart of saying, I want to protect the municipality, no matter how much you otherwise tipped the investigation, then you, as long as that was your thought, even if you're dead wrong 100% on how you execute it, then you are absolved from any liability.
Madam Chief Justice, I see I'm about to expire on time.
Please answer Justice Henry's question, and then we'll have to move to your co-counsel.
Thank you. Justice Henry, I believe the answer to that question is yes. Now, certainly, the conduct that you've described would likely give rise to a claim for arbitrary and capricious conduct. However, unless the reason for the use of an arbitrary and capricious review process was designed to create pretext to reject for a reason unrelated to performance concerns, the appellate authority and the Attorney General authority holds that that is not in bad faith.
Are you covering the motion in limine, or is your co-counsel covering that?
I'm able to answer any questions that the panel might have on the First Amendment issue.
If a contractor has a track record of only successfully seeking change orders and suing a municipality, is that a mark to be held against them?
Sorry, could you repeat that question for me?
You're having this argument about admissibility of a contractor seeking change orders and suing a municipality. I could understand why you wouldn't want to hire somebody who, sues municipalities. But if their track record is 100% win, in other words, they've been right every single time, right, is that something a municipality can hold against them?
According to the Attorney General's office, yes, it is. And I would add that I think part of that rationale would be because it creates a potential for an acrimonious adversarial relationship between two contract parties, which could affect the ability of the parties to work together harmoniously, which is one of the components of the public interest listed in the statute.
Is there a point, just switching back to the other topic for a minute, is there a point where the city's review process is so unfair that a jury could infer that it was unreasonable and didn't have a proper motive, couldn't possibly have a proper motive?
I would cite to this Court's 3 decisions in Roblin Hope Industries, Bradford and Bigelow, and Northeast Reclamation, where this Court found evidence of the use of an unfair process as pretext for an ulterior motive was the key to supporting the bad faith decisions.
Okay, we're going to have to leave it there. And Mr. Kerrigan, I assure you, if you need extra time, I will give that to you. Mr. Ryan, you have 5 minutes.
Madam Chief Justice and Associate Justices, may it please the Court, my name is Stephen Ryan on behalf of the City of Worcester, the appellant, and I'll be arguing the damages issue this morning. Your Honor, the City appeals the award of damages to REVOLI in this matter, and specifically the Court's decision denying the City's motion for a new trial on damages. REVOLI was awarded lost profit damages in the amount of $3 million. It asked for damages in the amount of $4.6 million. The City suggested that damages should be placed at $344,000 based on its own expert testimony. Now, the jury came back with an award of $3 million. The Court, in denying the motion for a new trial on damages, said that the jury was entitled to come to a conclusion somewhere in between those two poles. We simply don't accept that analysis because that takes away the requirement that the jury get outside of the realm of speculation and conjecture. They were presented with a number of $4.6 million. They were presented with a number of $344,000, and they chose a number of $3 million, which is a round number. Unfortunately, it bears no rational relation to any of the evidence submitted really by either side.
It's the jury, right? So is your contention that a jury verdict for an amount of damages needs to come with a spreadsheet or some kind of rationale?
No, Your Honor. That is absolutely not our contention, and we understand that this court will only set aside a jury verdict if there's no rational basis in the record for that finding of fact, because that's what it is a finding of fact. But what we do say is that this court's own precedent establishes that this court, the appeals court, has not uncritically accepted jury verdicts or judicial bench verdicts, even when supported by substantial evidence. So in the jury verdict context, the Brewster wall coverings case, that was a $5.3 million jury verdict, which the appeals court held had to be remanded for a new trial on damages because they had not been sufficiently proven and they had not been taken outside the realm of speculation and conjecture, which is the entire point of proving lost profits. Now, lost profits is a little bit of a different breed of damages, and it does require a certain level of proof, in a certain level of rigor in that proof. And the other case I wanted to cite to is the renovator supply case, where a judge had made – actually, that was a case where it wasn't a jury, but a judge, Your Honor, had provided detailed written findings and was the finder of fact there. And the appeals court said, no, there's an element of uncertainty in the judge's mathematical calculations, and we have to remand for a new trial. We think that there is certainly an element of uncertainty in this case, and the reason is because although there is certainly a lot of documentation of record, that does not mean that REVOLI submitted sufficient evidence to prove its lost profit damages.
So they argue back that this $3 million number could have easily been explained by testimony from witnesses, and they give two examples. You could, because of this labor cost situation, you could decrease the profit by $1 million, and because of the staffing, the jury could have concluded that there would have been a higher supervision cost of around $600,000, and that would get you to the $3 million. What do you say to that?
Well, our answer to that, Your Honor, is that REVOLI's damages evidence in the first place was not supported by sufficient evidence. So it was necessarily speculative to get to any number above and beyond.
Why is the owner's testimony as to what he generally seeks as profit? And I know we have a case that says this because I was sitting on it. The owner's testimony is good enough for what profit is. You might not agree with it, but why is that not good enough?
Well, Your Honor, I would say in this case that there was expert testimony, and the city's expert looked at 14 years of audited financial statements. There's a reason we believe that REVOLI, which had the burden of putting in evidence, chose not to submit those documents. It's because they knew that those documents would undercut their claim for damages. Our expert was able to determine that based on 14 years' worth of audited financial statements, its average profit on only two matters where it had $10 million or more contracts, it only had two $10 million contracts in its history, was between 0 and 5%. And that's why, with further analysis, he settled on a damages figure of $344,000, which was 2.5%. REVOLI was asking essentially for 30% windfall damages.
I mean, why can't the jury conclude, though, that that means that they weren't good at bidding bigger projects? Because that's a really low profit number, and so they did a better job on bidding this project.
Well, Your Honor, I don't think that's not what the measure of damages is what the lost profits would have been, and there's a measure of speculation inherent in that line of thought that we disagree with, and we don't think the jury should have applied. We think that it was untethered to actual rigorous analysis. We think that the city, although it wasn't required to, showed that REVOLI's damages figures were not accurate, not appropriate, and we would ask that the court remand for a new trial on damages.
Thank you, Counsel.
Thank you, Your Honor.
If you need it, an additional $245. Attorney Kerrigan, when you're ready.
May it please the Court, David Kerrigan for the appellee, REVOLI Construction, Inc. REVOLI asked that the Court affirm both the court's orders on the post-trial motions and the jury verdict.
And if we did that, that moots your cross-appeal.
That's right.
Can I ask you, at page 37 of your brief, you make an argument about burden shifting. And I just want to understand. I understand that you had the burden of production and the burden of persuasion, but that doesn't negate the presumption of good faith. So the way you've set up the construct is, I read it as saying the burden, your burden is so great that it's irrelevant, the presumption. I don't know that I agree with that. So help me understand the argument.
Yeah, okay. Thank you, Your Honor. Our presumption argument is this. One, I think the judge was legally correct on declining to instruct on the presumption of good faith, number one. Number two, he also expressed concern, and I do think he was right, that it would create and lead to jury confusion. And number three, and therefore it was in his discretion. And lastly, they can't show that the outcome would have been different. So let me focus on, first, legally correct. Why I think the judge was legally correct in not instructing on that issue. And it took me a little bit. If you go to the Mass Guide of Evidence, which I cite, that says that presumptions in civil cases under Massachusetts are applied when they help the party with the burden of persuasion by shifting the burden of production on that issue to the other side. So, and here, because we always had, REVOLI, the burden of persuasion on bad faith and production on that issue, there was nothing to shift. The examples that the guide then uses I think are helpful once I really looked at them. One is Jacobs versus the town of Arlington, and that's where the person sought a death certificate because he hadn't been seen for 7 years. And under the law, when you're not seen for 7 years, that creates a presumption of death. So he was the plaintiff who had the burden of persuasion, but it shifted the burden of production to the town to say, oh no, here are reasons why he's alive. And there's other abutter cases, and I think you might have an abutter case on, but generally abutters have standing because they're presumed harm when they challenge a project next to it, generally. And so it then would shift the burden of production. No, you don't have standing, to the other side. And so in that sense, because we always had a higher burden to show bad faith, and if you look at the cases, the Bradford versus Bigelow, the Northeast Reclamation, they don't refer to the presumption of good faith when they refer to the jury instruction given. And I think the judge was correct in saying, I don't think it belongs in a case involving the instruction on bad faith, using the Spiegel instruction, because there's nothing to shift. We always have it. So
is that why it's a de novo review and not an abuse of discretion review?
Well, it would be for the jury instruction, but you do also have to look at discretion, because in jury instructions the court has some discretion on how to instruct. So on that issue, and I've thought about this too. I think the judge was concerned that he knew there was a lot of evidence in favor, I think, of the bad faith. Given the emails, we don't want them. Let's look, the city wants us to look into throwing them out. They're contacting another engineering firm saying, we want to build a case to reject them, not to evaluate them. And all of that. And the unfairness between the way they did the evaluations, ignoring all the good for REVOLI, focusing on the bad, ignoring all the bad about the second low bidder, focusing on the good, all of that. I think the judge was concerned that if he gives the presumption, because once there's some evidence in favor of the bad faith, then the presumption disappears. It's like a bubble that goes away. And then so if you do that, well, at what level, if it goes away, then would the jury then think, oh, it automatically goes to bad faith, once you get some evidence? And so I do think the judge was well within his discretion to say, I'm just not going to do that. And lastly, I just don't see how they can say that the outcome would likely have been different given the evidence.
But they basically are saying that that as long as they had a real, true, sincere concern about protecting the public fisc, that you can't infer bad faith by any of the evidence you just mentioned or you recite in your brief. What's wrong with that?
Yeah, we disagree with that.
I got that, but why legally?
Yes, for a couple of reasons. One, we don't agree with the notion that they had some sincere good faith belief, because that wasn't exactly what the evidence was. And we go back to, what did they know? When they sent those, the email exchange on the day of the bid, within an hour and a half of the bid being opened, what did they know then? And the evidence was just, the person who was the real decision maker, the commissioner, said, I had no experience with them. I didn't know anything about them. I had no prior knowledge of them. And there were these two people, one from the city, Mr. Elbag, and one from the outside engineering firm, Mr. DeCruz, who were talking about them. And both sides said, well, he expressed concern. No, he expressed concern about REVOLI. And what it was they were, quote unquote, difficult. And one said they have a reputation for changes, for change orders, or litigious. And that's all. That's all the evidence was on their so-called prior knowledge and good faith. And given how they ultimately did the award, that is not a sincere belief, number one. But that's not what they're saying for this constricted meaning of bad faith is not the law. In fact, if you look back to Spiegel, it says time and again, it has no constricted meaning.
So what about this Attorney General decision that he's relying on that had facts that were similar, not exact?
There's a couple things about the Attorney General decisions. There's a case, I think Boston Water and Sewer, 18 Mass App Court, where they talk about the effect of those decisions. Those decisions, it's an informal hearing. You review them de novo. There's not an administrative hearing. There's informal processes. And the court looks at those de novo. They don't really have any weight in court. There's no evidence that they knew about that decision either. And I think on that very decision, if I recall near the end, they say this. The decision maker says, it would be an affront to the bidding laws to blacklist someone based on that type of evidence. Despite that, they found it was arbitrary. It was not arbitrary, which I disagree with. I disagree with the decision, but I don't think it was subject to review. And I agree with that phrase. It would be an affront to the bid laws for a city like here to consciously disregard what the law requires. Because
so he's saying that if we affirm this verdict, we're going to chill all towns and, the parade of horribles, that all construction is going to be terrible and towns are going to be too afraid to do a legitimate check of people's experiences.
I disagree with that, because I think what the jury, I think it would send a wrong message, and the opposite, that then cities, awarding authorities, can rely on rumors, innuendo, reputation, to say we have the public interest at heart, and ignore what the legislature has said in its statute on how to do the review, and what this court has said. Fair, open-minded, equal footing, no favoritism, no predetermination outcomes. And then to say that they have more knowledge and a more sincere belief, I think, is wrong. But if I could, Your Honor, I'd like to read what really bad faith is. This court has said in the Bank of America case, the focus on knowing and conscious wrongdoing lies at the heart of all subsequent uses of that term of bad faith in our decisions. And that's what happened here. The evidence was clear that they knew what the bid laws required. They knew they were supposed to be done fairly, equal footing, no favoritism, and they admitted that if they had predetermined the outcome, that would be bad faith.
So did you, a witness giving an opinion of law doesn't really help you, but do you agree, because they say this, that you did not offer evidence of bribery or corruption?
Oh, yes, we did, yes. There wasn't evidence of bribery.
So why? Then why, what, is there because they're saying you can't draw an inference from this, did you offer any explanation as to why?
As to why they did it, they relied on some reputational evidence that they had they were quote unquote difficult, whatever that means. We don't really know. Does that mean someone somewhere had a hard time with a supervisor? Were they, because it should mean, did they do bad work? But there's no explanation for that. Is it the change orders? Is that it? Because they, as we say, exercise their right to petition or bring cases in court? Is that it?
Well, assume for a moment, obviously this is not this case, and I apologize, I'm having some back pain, so I'm going to move around a little bit. But assume that a contractor has a history of filing litigation against a municipality, and let's assume they lose every single case, right? Can the city can't the city consider that?
Yeah, I think it.
I mean, you wouldn't hire them to paint your house if that was the case, right?
Probably not, Your Honor.
None of us would.
Probably not. But if I know they file multiple cases and lose, and there's some sort of judicial finding, a frivolous or vexatious, something like that, sure. But here, that wasn't the evidence. Because what they testified to was, one, we don't know whether any of the change orders and any of these, reviews were valid or not. We knew nothing about the litigation. And in fact, they said, we don't know whether, generally, change orders don't affect a project, because the contractor is obligated, when they seek more money, to continue the construction. So they relied on that, but there was none of what you're saying in terms of whether they're insubstantial or frivolous or losing. They didn't know anything about them, Your Honor. So I think that is an important factual distinction here.
So let's assume for the moment that because they're arguing, had this presumption been, the jury had been instructed about the presumption of good faith, they're saying that it could have affected the outcome. You're saying, it would definitely not have affected the outcome. How do we judge that?
Well, because I think you look at the instruction on bad faith was correct, and they don't, attack that in any way. So we had and met a higher burden. We met a bad faith instruction that it could be deception, a conscious doing of a wrong, or other element that has been accepted for over 100 years. So given that, it's a higher burden that, the judge went through. We had to prove each of the elements by a preponderance, and the burden of persuasion and production was always on us. So given that, I don't see how it would not have affected the outcome. I think there was also elements, Your Honor, of some deception. For example, they had to present to the city manager. They didn't tell the city manager, just to let you know, we heard bad things about REVOLI from the start, and we didn't want them, and the evaluations confirm that. They said, well, we found some bad things about REVOLI, we rejected them, we're going to GIOSO. They don't say, we also found that GIOSO had 26 safety violations from OSHA and was in a severe violator program, and we only found 2 for REVOLI. So I think the jury could have found there was some deception involved. Mr. Al-Sarabi, the principal of REVOLI, called in September and said, gee, I'm hearing about your contacting references. Here's some others if you have any concerns. By that time, they said they had made up their minds, and it was done. And they don't tell him, just to let you know, we've already made up our minds, and we're not calling anyone. Instead, they do speak to people, and they ignore the good evaluations that they've received from that call.
So are you saying, though, like one of the examples was, and this bears a little bit of a resemblance to the judicial selection process, that the governor is not limited to the references we put on our application. In fact, you're pretty much told that you're guaranteed those people won't be called. They go off the references. So if the city goes off the references of one candidate, do they have an obligation to go off the references for every candidate?
Well, I think for that, they should do it, and there may be an equal footing issue that may become arbitrary, but just doing that in and of itself may not be bad faith. But we have much more. And can I?
Analogizing, though, to the employment context, we have plenty of cases that say we're not going to become a super HR department, because sometimes you get some information on a reference and then that you keep pulling the thread, and maybe you don't get that for the other candidates, so you don't need to check 10 references, you only need to check 5 for them, but you do need to check 10 for the others. That okay?
No, I would think that's okay. Yes, yes. And can I point out about the fundamental argument, like, do you need sort of the corruption or the bribery? There's a couple cases, I think, that deal with that issue, and that's the Pheasant Ridge, which is a bad faith challenge to eminent domain, where the court upheld a summary judgment that found there was bad faith. There, it was just because they took the land not for a public purpose, and not for bribery, not for corruption, but they wanted to avoid the traffic and other effects of low-income housing. So it's a very similar thing, like the Burlington was saying, we want to do this to protect the public interest, but it's still an improper use of the eminent domain. The Northeast Reclamation, which is a bad faith bid case, also was they wanted really to avoid litigation and the cost with litigation, because the number one bidder said, we're going to sue you if you change. So I think that it answers that question. Now,
can we just turn to the damages issue for a moment? And they do cite a case in reply, Cummings versus Standard Register. I'd like your take on, but my real question is, he's saying, look, 14 years of audited financial statements, their profit was, no more than 5%, and apparently they were terrible at bidding, and could even be 0 to 5%. Not really sure why you would stay in business if that's what you were getting, but and so really the jury is just, I guess, splitting the baby in that's not okay. You can't discern a basis.
Well, we do disagree with that, because the audited financials, the evidence was he has some other companies, number one, that's included in that, not just his REVOLI construction. Number two, the audited financials for projects don't have all the projects in 1 year. Sometimes they straddle years, but so it's a little inaccurate for what their profit margin is. And lastly, Your Honor, the job registers, which were in evidence as Exhibit 18, I think are a better reflection, because that's a project-specific profit versus a financial statement that has other companies and incorporates their overhead when they don't win jobs, right? Because they incur costs on bidding and things like that aren't recovered by a per-job basis. But here, the evidence was, I think, clear from the owner that here's how I bid the job. You have the 150 or so costs. Here were my direct costs. Here are my indirect costs, and I'm adding $4.6 million to win this job, and that's what he expected to win.
And there was no special questions in this case, right?
No, not in the sense of dividing things up. No. And I do think there are multiple ways the jury could have got there in terms of, taking some of the evidence from one of the experts and applying it to what the evidence was on the damages.
You mentioned something called job registers. I just want to make sure
I'm
where
sorry.
those. No, don't apologize.
Yeah.
I don't know that I know what that means. So I was wondering where in the record I would find that.
Thank you. It's Exhibit 18. It's in Volume 6, page 256, starting at. What are those? He does like a per job, cost.
That's fine. I just wanted to make sure.
And those range from like 12 to 150%. And
I think we may have to leave it there. I don't see any other questions. Counsel, very well argued case. It is under advisement. Thank you all.
Thank you.